that name, KG. I don't know who is the person.
Okay. Council can announce the appearance.
May it please the court. Olatunji Abisogun is my name. My lord, I appear for the claimant. My lord, the claimant is also online. That's the
Okay.
KG.
Okay.
My lord, with the most profound respect, my name is Opeyemi O. Adeyemi. Your lordship, my humble appearance is for the defendant. I most humbly apologize for his absence, my lord.
Okay. So this is the judgment of the court between Mr. Moreni Keji Asimiyu and Afis Oloyede, the defendant, trading under the name and style of Bam 363 Photography. Where of the claimant claims against the defendant as follows. 1. A declaration that the claimant was in the employment of the defendant and as such entitled to salary until his employment was wrongfully terminated by the defendant via the letter of 30th April 2022. 2. And a declaration that the action of the defendant threatening the claimant with the loss of his job, referencing the reason that the defendant has numerous applications for photographers via mail dated 22nd day of April 2022 amounts to an unfair labor practice. 3. A declaration that the purported termination of the claimant's employment by the mail/letter of 30th April 2022 is wrongful. 4. A declaration by this court that by the virtue of the letter of employment dated 8 November 2020, the claimant's pension account number PN 110072537357 maintained with leadway pension must be credited with 18% in bracket inclusive of the defendant's contribution of the claimant's basic salary, housing allowance, and transport allowance from 1st of January 2021 till date. 5. A declaration by this court that the sum of 82,000 naira, 193 naira paid into the claimant's pension account number PN maintained with Leadway Pension PFA Limited is grossly inadequate of the pension contribution of pension earned by the claimant from 1st of January 2021 till date. And 6. Another of this court directed the defendant to pay the sum of 142,000 naira and 50,157 naira, representing the deficit of the remittance by the defendant to the claimant's PFA maintained with Leadway Pension PFA Ltd. And 7. A declaration by this court that the act of the defendant refusing to or failing to credit the claimant's pension account number maintained with Leadway Pension PFA Limited accurately and appropriately is oppressive, wrongful, and a violation of the claimant's right as protected and preserved by the Pension Reform Act. And 8. Another of this court directing the defendant to pay to the claimant the sum of 115,000 naira, representing the claimant's salary for the month of April 2022. And 8. Another of this court directing the defendant to pay to the claimant the sum of 115,000 naira only, representing claimant's salary for each month starting from May 2022 until the judgment of this court is delivered. And 9. Another of this court directing the defendant to pay to the claimant the sum of 115,000 naira only, representing his 1 month salary in lieu of the 1 month prior notice of his termination, as stipulated in his contract of employment dated 8 November 2022. And then 15% compound interest on the total sum awarded until the sum is fully paid. And 3 million naira damages against the defendant for unfair labor practice, wrongful termination, and loss of earning. And 500,000 naira only against the defendant as cost of this suit. The harmonized facts. The claimant was employed by the defendant trading as Bam 363 Photography as a photographer/retoucher with a relationship commencing on November the 18th, 2022. The initial terms of engagement were contained in an offer of employment letter dated November 8th, 2022, which the claimant accepted. The defendant asserts that a subsequent employment contract was issued and accepted by the claimant on the 1st day of February 2021, which the defendant claims modified the initial terms. The defendant maintained a Bam 363 staff handbook, which was referenced in the initial offer letter as containing disciplinary rules and procedures. The defendant contends that page 4 of the said staff handbook maintains an express disclaimer stating that the document does not constitute a contract of employment or a legal document, although the claimant was enrolled in a contributory pension scheme with Leadway Pension PFA Ltd during the course of his employment. A dispute exists regarding the commencement date of the pension obligation. The claimant seeks contributions from November 2020, the initial date of employment, while the defendant maintained the scheme only became operational in February 2021. The claimant attributes the increase in his gross monthly salary from 80,000 naira to 33,000 naira in May 2021 to his sterling performance, whereas the defendant asserts the increase was intended to cushion the impact of statutory deductions and taxes. The defendant further claims to have remitted a 10% employer contribution and deducted an 8% employee contribution for the claimant's basic salary starting from February 2021. The employment relationship was terminated by the defendant via an electronic mail titled, and I quote, letter of termination of employment dated April 30, 2022. The claimant alleges that this termination was wrongful and seeks judicial redress, while the defendant maintains the termination was a valid exercise of rights under a master-servant relationship. The claimant tendered the following documents as they were admitted, and marked as Exhibit C1 to Exhibit C11. The defendant also tendered the following documents in evidence, and they were admitted and marked as Exhibit D1 to D9. The details of the exhibit are all in the body of the judgment. Also in the judgment, I have the defendant's final written address. I have the claimant's final written address. I'll go straight to the decision of the court. In the defendant's final written address, he raised an issue whether the originating process in this suit is competent, having not been signed by either the claimant or his legal practitioner as fundamentally required by law. This question has been consistently considered by the courts. The Supreme Court has unequivocally held that the issue of signing an endorsement of an originating process by a legal practitioner is a requirement of substantive law and not of procedural law. This means it goes to the root of the court's jurisdiction and the competence of the process itself. It is not a mere irregularity that can be overlooked or cured by the court's decision. See State versus Agabi, State versus Gideon, State versus Boniface, and State versus Amos and Ume and CBN citations are all provided. It is settled principle of law that the signing of a court process is a statutory requirement that directly impacts the competence of the process. An improperly signed process therefore affects the competence and jurisdiction of the court to entertain the matter. It is a fundamental issue that cannot be waived, as decided in Ilokosun and Union Bank, on Motsali and Onyero. Citations are all provided. A combined reading of provisions like Section 2, Sub 1, and Section 24 of the Legal Practitioners Act, which is a substantive law, makes it mandatory for an originating court process filed by a legal practitioner to be signed by him to invoke the court's jurisdiction. See Abeng and Ego citation are also provided. Given that it is a substantive issue of affecting jurisdiction, the requirement for proper signing cannot be waived by the parties either by consent or inaction. See Omatsali Onye, Supra and Mancha and Emukowate. It can be raised at any stage of judicial proceeding, including for the first time at the Court of Appeal or even at the Supreme Court, as a jurisdictional issue. The courts have also held that it is irrelevant whether the parties complaining about the non-signing of the court process suffered any miscarriage of justice or prejudice. The defect is fundamental and renders the process incompetent, regardless of its practical impact on the fairness of the proceedings. In Bello and Federal Mortgage Bank, the Court of Appeal held that the requirement is for the process to be signed in the name of a known legal practitioner, not in the name of a legal firm. Signing in the name of a legal firm is considered an improper signing and renders the process incompetent. In the instant case, parties in their final addresses canvassed arguments that the claimant's general form of complaint was not signed by the counsel, although the defendant participated in the entire proceeding till filing and adoption of final written address. The defendant went ahead to interrogate the court's jurisdiction and the competence of the process. That being the case, the court therefore took time to examine the case file and noted that on page 18 of the case file, the general form of complaint was dated 8th day of June 2020, and the counsel has a signature appended at the bottom right-hand corner of the page. On page 19, the counsel also had a signature appended at the top right-hand corner of the page, and his name, Olatunji Abisogun A. Esquire is typed beneath his name and ticked. Attached also is his NBA seal. Considering the above evidence in the court file, this court is convinced that the claimant's legal counsel properly signed the court process, especially the general form of complaint. There is no doubt as to the competence of the process and the jurisdiction of the court. In the circumstance, this court has the competence and the jurisdiction to hear this matter, I so hold. For relief one, the claimant is seeking a declaration that he was in the employment of the defendant and as such entitled to salary until his employment was wrongfully terminated by the defendant by the letter of 30th April 2022. Parties are in agreement that there exists an employment relationship between them. By the letters of employment Exhibit C1 and D1, it is established that the claimant was known and engaged as an employee. It is right that an employee is generally entitled to wages, but his entitlement is subject to various conditions and circumstances as established by Nigerian labor law and judicial pronouncement. The fundamental principle is that wages are compensation for services rendered during a period of lawful engagement. More importantly, is that an employee is entitled to wages and salaries for the period during which they are lawfully engaged in service and have rendered work. The courts have, however, held that the employer is not obligated to pay wages or allowances to an employee who has not worked for the period of employment. So, for an Anambra State Education Council citation provided. This establishes a direct link between work performed and the right to remuneration. In the circumstance, relief one succeeds to the extent that is entitled to salary until his employment was terminated by the defendant by the letter of 30th April 2022. Relief two is a declaration that the action of the defendant threatening the claimant with the loss of his job, referencing the reason that the defendant has numerous applications for photographers via email dated 22nd April amounts to unfair labor practice. Unfair labor practice is a crucial concept in labor law, designed to protect the rights of employees and to ensure equity and fairness in the workplace. An unfair labor practice refers to actions undertaken by employers or even employees that contravene the rights established in labor law and regulation. Such practices inherently disrupt the equilibrium of fair labor relations and undermine the fundamental principle of equity, fairness, and justice within the work environment. The Court of Appeal in the case of Pilgrims Africa Ltd. and Boyson 2025 provided a clear articulation of what constitutes an unfair labor practice. The court stated that these practices are those that violate enshrined labor rights and regulations, thereby disturbing the balance of fair labor relations and undermining principles of equity, fairness, and justice. The court went further to state that unfair labor practice can encompass a wide range of actions, including discrimination based on protected characteristics, wrongful termination, harassment, retaliation against whistleblowers, interference with union activities, and failure to provide safe working environment, among others. On the legal nature of unfair labor practice, the Court of Appeal in Pilgrims Africa versus Boyson Super clarified, and I quote, that international best practice or unfair labor practice is a question of law and not fact. This means that whatever a particular set of circumstances amount to, an unfair labor practice is a legal determination made by the court. The court assesses the facts presented before it, juxtaposing them with the relevant legal principles to ascertain if an unfair labor practice has occurred. The role of the statement of fact in a legal proceeding is to clearly and precisely present the claimant's case, not to argue points of law. In the instant case, the claimant avers that the mail of 22nd April 2022 entered at Exhibit C2, where the claimant was threatened with the loss of his job by the defendant, referencing numerous applications for photographers, amounts to an unfair labor practice. From the pleadings to paragraph 23 to 25 of the statement of fact, this mail was received a few minutes after the claimant had informed the defendant that he had changed his mind and would report to work at a location, in brackets, Surulere, outside his area of residence, which he had earlier declined due to ill health. To the defendant, in paragraph 24 of his statement of defense, this was a notice drawing the claimant's attention to his insubordination. From the facts presented, this cause is not swayed to refer to the mail as an act of unfair labor practice. The position of the law is that an employer can draw the attention of his employee to shortcomings and lapses. The law recognizes the employer's right to manage their workforce and ensure that the employees perform their duties to the required standard. An employer can certainly draw the attention of an employee to his shortcomings and lapses at work. This is the fundamental aspect of the employee-employer relationship and is essential for performance, management, productivity, and maintaining standard within an organization. When an employee fails to meet the terms of their condition of service or performance or performs unsatisfactorily, it is within the employer's right to address these issues. The Court of Appeal in Alhaji Gujba and First Bank of Nigeria citation provided emphasized this principle that, and I quote, It does not lie within the province of an employee to determine the kind of a disciplinary measure or punishment that should be inflicted on him when it is established that he has failed to work in terms of his condition of service to the satisfaction of the employer. End of quotation. This principle clearly indicates that the employer has the authority to assess an employee's performance and take appropriate steps, which would naturally include pointing out shortcomings. It must be noted that the ability to draw attention to shortcomings is a necessary precursor to or a mild form of disciplinary action. If an employer cannot address unsatisfactory performance, they would be unable to maintain efficiency and to enforce the terms of employment contract. The discretion of an employer in managing their workforce is broad, as highlighted in NDA versus Ayedegu citation presided, which noted that, and I quote, an employer has no obligation to give any reason for determining an employment at common law. While this court concedes that this specific case relates to termination, it underscores the significant control an employer has over the employment relationship. If an employer can terminate an employment without giving reasons, it logically flows that they possess the lesser right to address performance issues and shortcomings to prevent such a drastic step. Given that this mail in reference exhibit 2C, C2 fails as an unfair labor practice, can it even be referred to as ill treatment? Drawing an employee's attention to their shortcomings when done professionally, constructively, and in good faith does not constitute ill treatment under Section 46 of the Labour Act. This section prohibits employers from neglecting or ill treating workers. Legitimate feedback and performance decisions are standard management practices aimed at improvement, not abuse. The purpose is usually to guide the employee towards better performance, provide an opportunity for correction, and ensure that the employee understands the expectation of their role. It is therefore the finding of this court that an employer has a clear right to draw an employee's attention to their shortcomings and lapses at work. This is a legitimate exercise of managerial prerogative aimed at ensuring satisfactory performance and maintaining workplace standards. Such actions are typically part of performance management process, which may involve verbal warnings, written warnings, performance improvement plans, or other disciplinary measures, depending on the severity and persistence of the issues. The law supports the employer's right to assess an employee's performance and address any failures to meet the terms of their employment. In the circumstance, Relief 2 fails, I so hold. Relief 3 is for a declaration that the purported termination of the claimant's employment by the mail of 30th April 2022 is wrongful. The claimant argues that his employment was wrongfully terminated by the defendant via an email dated 30th April 2022. The claimant asserts that his performance was satisfactory and sterling, as evidenced by the defendant's decision to confirm his employment and provide multiple salary increments in May 2021 and February 2022. The claimant contends that the defendant made reference to a staff handbook in the letter of offer which set out disciplinary rules and procedures, implying that termination should have followed a specific due process which was allegedly bypassed. The claimant relies on a letter of offer of 8 November 2022 and the staff handbook to establish a standard for lawful termination, suggesting the summary nature of the email termination was a breach. In Nigerian law, an employer can terminate an employee for any reason, provided the termination follows the contractual or statutory notice period. The use of email is a valid modern medium for communicating such termination. In Nigerian labor law, the resolution of wrongful termination remains claimed. In Nigerian labor law, the resolution of wrongful termination claims in a master-servant relationship depends on the terms of the contract of employment. As established in the landmark case of UTC and Peters, an employer possesses the right to terminate an employee's service for good reason, bad reason, or no reason at all, provided the termination is carried out in accordance with the contract. The burden of proof lies squarely on the claimant to, 1, exhibit the contract of employment, and 2, prove the specific manner in which the term was breached, as held in Nigerian Security Printing Meeting PLC versus Sumo. Under the Labour Act and common law principles governing private employment, the private remedy for termination without adequate notice is the payment of salary in lieu of notice. However, the termination is deemed wrongful only if the limited extent of the notice period is wrongful only to the limited extent of the notice period. Since the claimant was employed for approximately 17 months, he was entitled to a minimum of 1 week's notice under the Labour Act. In employment law, payment in lieu of notice is generally expected to be made contemporaneously with the termination or within a reasonable time immediately after termination, depending on the contract and applicable labor law. Where an employer terminates an employee's appointment without the required notice, salary in lieu of notice must be paid immediately at the time of termination. The Supreme Court case in John O. Oforishe versus Nigerian Gas Company Ltd. reaffirmed that where a contract permits termination by notice or salary in lieu of notice, the payment must accompany the termination and not be delayed. The courts have consistently held that merely promising to pay salary in lieu at a later date does not amount to compliance with the terms of the contract. In practice, payment in lieu is expected to be made on the effective day of termination, simultaneously with the termination letter, or as part of terminal benefits processed immediately where permitted by workplace policy or contract terms. Where payment is made substantially later without justification, the employer may be found to have breached the contractual termination procedure, thereby rendering the termination wrongful. However, in an ordinary master-servant employment relationship without statutory flavor, such wrongful termination does not make the termination void or entitle the employee to reinstatement. The remedy available is usually damages equivalent to the notice period or the unpaid salary in lieu of notice. Going by Section 11, Sub 2B of the Labour Act, specifically maintaining a minimum notice period of 1 week for an employee who has been continuously employed for more than 3 months but less than 2 years. This provision ensures that neither party is left abruptly without recourse, and its breach entitles the aggrieved party to payment in lieu of that notice under Section 11, Sub 6 and 9. Furthermore, the court in UTC versus Peter Supra established that in a master-servant relationship, the motive for termination is irrelevant. The court only looks at whether the contract was terminated according to its terms. Additionally, Nigerian Security Printing and Umos case reinforces that the measure of damages for wrongful termination in private employment is strictly the salary for the period of notice the employee would have been entitled to. Therefore, the defendant's exercise of termination is valid only to the payment of the statutory notice period. In the instant case, the court examined the email termination dated April 30, 2022, and noted that the requisite notice period stipulated in the offer letter of Exhibit C1 of November 8, 2022 is 1 month notice, while Exhibit D1 offer letter of February 1st, 2021 provided for 3 weeks. It is not in doubt that the defendant failed to provide notice, as DW1 under cross-examination admitted that she did not have such a notice. The court nevertheless noted that the defendant leaned heavily on the fact that it made payment in lieu of notice. However, the court noted that the payment was made on the 2nd day of May 2022, which is the following month after the claimant was terminated, tendered as Exhibit D9. The termination of the claimant's employment via email is resolved as not being wrongful in principle, as the defendant exercised its inherent right under a master-servant relationship to terminate the contract. The act of making payment in May 2022 for a termination that took effect from 30th of April was wrongful, I so find. The claimant argues that pursuant to the Pension Reform Act and the letter of employment, pension contributions were to be assessed from the sum of basic salary, housing, and transport allowances. The claimant provides a specific breakdown for the initial 80,000 naira monthly salary, where the 8% contribution was 6,400 and the defendant's 10% obligation was 8,000 naira per month. The claimant further asserts that when his salary increased to 93,000 in May 2021, his monthly contribution should have been 7,440,000 naira, representing 8%, and the defendant's contribution should have been 9,300, representing 10%. The claimant claims that the defendant was obligated to contribute these sums to his account with Leadway Pension PFA Limited, but implies a failure to do so correctly or fully, totaling 83,700 naira for the period between May 2021 and January 2022. The argument is evidence-based, relying on the specific figures and the statutory percentages mandated by the Pension Reform Act. The defendant, on the other hand, argues that the initial contract dated 8 November 2020 contained no clause providing for participation in a contributory pension scheme. The defendant asserts, as a matter of fact, that the business had no pension scheme in place until February 2021, making compliance impossible prior to that date. The defendant maintains that the claimant accepted the terms of the 2021 contract, which excluded pension, and therefore cannot unilaterally vary those terms retrospectively. The defendant is relying on the four corners of the written contract and the factual timeline of the scheme's implementation. The defendant further denies the claimant's allegation in paragraph 10 and 12 of the claim, asserting that the 10% contribution was consistently made based on the correct basic salary/allowance figures. The defendant provides specific figures, which is 5,400 monthly for the second period and 6,900 monthly for the final period, representing 10% of the pensionable sum. The defendant claims to have remitted even more than the pension contributions required under the February 2021 contract. The defendant shifted the burden to the claimant to provide evidence as of deficit in the pension fund account. In resolving this issue, it must be noted that the obligation to remit pension contribution is governed by the Pension Reform Act of 2014. Section 4 sub 1 of the Act mandates a minimum contribution of 8% by the employee and 10% by the employer. This is a statutory obligation that transcends private contractual arrangement if the employer meets the threshold defined in Section 2 of the Act, typically 2 or more employees. The defendant's argument that the scheme, and I quote, did not exist until February 2021 does not necessarily absorb it of statutory liability if the business was operational and met the asked criteria during the November 2020 to January 2021 period. I so hold. Under Nigerian law, specifically the principle in Pension Alliance versus Akinwumi, statutory deductions are mandatory and an employer's failure to remit them constitutes a breach of statutory duty. The discrepancies between the parties regarding the constituent of the salary, in bracket basic or allowances, is critical as the Act defines the contribution based on the sum of basic salary, housing allowance, and transport allowance. A comprehensive reading of Section 4 sub 1 of the Pension Reform Act mandates a minimum contribution of 10% by the employer and 8% by the employee. This provision applies to the fact because it creates a non-negotiable statutory duty that arises immediately upon the commencement of employment, regardless of the employer's internal administrative readiness. Furthermore, Section 11 sub 3 of the same Act requires the employer to remit the contribution not later than 7 working days from the day the employee is paid his salary, meaning the obligation is tied to the pay cycle, not the operational status of the scheme. In Veritas Capital Assurance versus Honor citation provided, the Court of Appeal held that statutory benefits like pension are mandatory and cannot be waived or delayed by the employer. Consequently, the defendant's delay in starting the scheme until February 2021 constitutes a breach of its statutory duty for the preceding months, I so hold. In seeking this claim, the court noted that for the claim in the month of November 2020 to January 2021, the defendant argued that it was not agreed in the contract of employment and cannot be unilaterally altered by the claimant as earlier stated in the judgment. This position held by the defendant is fatal as the statutory provision is settled and must be complied with whether it was expressly stated in any offer letter or not. I so hold. The claimant having shown by credible evidence that he worked for the defendant between November 2020 and January 2021, the obligation rests on the defendant to make remittances to the claimant's PFE. It is a considered view that the claimant succeeds in this regard. Consequently, this court grants orders for remittances for November 2020 to January 2021. I so find and hold. It must be noted that ordinarily failure to deduct the employee's 8% and the defendant's 10% portion renders the defendant liable. He is expected to remit the full 18% total to the PFA. Any failure to deduct at the source is the employer's administrative lapse. As for meeting the threshold for remittance, the evidence tendered marked at Exhibit D2 to D8 is proof that the defendant met the threshold as an employer to remit pension on behalf of the employees and was not exempted by the Pension Reform Act of 2014. That being established, this means that a minimum pension contribution must be assessed on basic salary, housing allowance, and transport allowance. However, where the contract of employment defines total emoluments more broadly to include other regular allowances, pension contribution may be calculated on the employee's total emolument or gross pay. Since pension contributions are calculated on monthly emolument, the Act defines monthly emolument as the total emolument as may be defined in the employee's contract of employment, provided it is not less than the total of the employee's basic salary, housing allowance, and transport allowance. End of quotation. Accordingly, the legal position is that pension contribution cannot be calculated on anything less than basic salary, housing, and transport allowances, but may extend to total emoluments if the employment contract so provides. This being the position of the law, can the claimant succeed under Relief 4 and 5 for declarations that by virtue of the letter of employment dated 8 November 2020, his pension account maintained with leadway must be credited with 18% inclusive of the defendant's contribution of the claimant's basic salary, housing allowance, and transport allowance from 1st of February 2021 till date? Relief 1 succeeds to the extent that his pension account must be credited with 18% inclusive of the defendant's contribution of the claimant's basic salary, housing allowance, and transport allowance from 1st of February 2021 from the date of appointment to the date of termination, which is 30th of April 2022. I so hold. For Relief 5, that sum of 82,193,000 paid into the pension account number maintained with Leadway Pension PFA Ltd is grossly inadequate of the pension contribution of pension earned by the claimant from 1st of February 2021 till date of termination. The claimant provides a specific breakdown for the initial 80,000 monthly salary. The 8% contribution was 6,400, and the defendant's 10% obligation was 8,000 naira per month. The claimant asserts that when his salary increased to 93,000 naira in May 2021, his monthly contribution should have been 7,440,000 naira, representing 8%, and the defendant's contribution should have been 9,300, representing 10%. That the defendant failed to remit part of the contribution of 142,200 naira to the said account, while withholding the difference of 50,157 naira. This relief succeeds only to the extent that the sum of 82,193,000 naira was inadequately considered the above, was inadequate considering the above calculation. Therefore, the court grants Relief 6 for an order directing the defendant to pay the sums of 142,200 naira and 50,157 naira, representing the deficit of the remittance by the defendant to the claimant's PFA maintained with Leadway Pension PFA Ltd. I so hold. For Relief 7, this court hereby declares that the act of the defendant refusing or failing to credit the claimant's PFA accurately and appropriately is oppressive, wrongful, and a violation of the claimant's right as protected and preserved by the Pension Reforms Act. For Relief 8, there is evidence that the defendant made payment to the claimant in the sum of 115,000 naira, representing the claimant's salary for the month of April 2022, in the month of May. For Relief 8, there is evidence that the defendant made payment to the claimant in the sum of 115,000 naira, representing the claimant's salary for the month of April 2022, in the month of May, specifically on the second day of May, although it was late. This claim is therefore dismissed. For Relief 9, the fundamental position of Nigerian court is that an employee is paid for services rendered. This means that an employer is generally not obligated to pay salaries or allowances for periods during which an employee did not work. Several judicial pronouncements affirm this principle. In Philip versus Adisu Mubi, and other citations also provided, the Court of Appeal reiterated that, and I quote, a servant would only be paid for the period he served his master. Thus, an employee cannot make claims for salaries not earned. End of quotation. This case highlights that proof of entitlement to payment is often by reference to an instrument granting it, and an admission of not having worked for the period claimed negates the entitlement. Similarly, in one for an Anambra State Education Commission citation also provided, the Court of Appeal held that, and I quote, an employee is entitled to wages and salaries / allowances during the period of his or her lawful engagement in service. No employer is under any obligation to pay salaries, wages, allowances to an employee who has not worked for the period of his engagement. End of quotation. The court further clarified that a dismissed employee can only claim emoluments for work already performed. This position was also upheld in Balogun versus Union Bank citation provided, where the court stated that a dismissed worker, and I quote, a dismissed worker cannot claim for wages for services not rendered. End of quotation. In the circumstance, the claimant employment was terminated on the 30th day of April 2022. The defendant is under no obligation to pay to the claimant the sum of 115,000 naira, representing his claimant's salary for each month starting from May 2022 until the judgment of this court is delivered. Relief 9 fails and it is dismissed. Relief 10 is an order directing the defendant to pay to the claimant the sum of 115,000 naira only, representing his 1 month salary in lieu of the 1 month prior notice of his termination as stipulated in his contract of employment dated the 8th day of November 2020. Payment in lieu is a common practice in employment law, allowing for the termination of an employment contract without either party serving the full notice period, provided a monetary compensation equivalent to the notice period is paid. This practice is typically governed by the terms of the employment contract itself or by applicable labor legislation. Payment in lieu of notice refers to a sum of money paid by an employer to an employee, or less commonly by an employee to an employer, when the employee relationship is terminated immediately without requiring the employee to work through the stipulated notice period, primarily to compensate the party for the loss of the notice period, effectively substituting the requirement to serve notice with the financial equivalent, and payment is determined by the agreement between the employer and the employee as enshrined in the contract of employment and by any relevant statutory provision. This provides flexibility for both parties, allowing for a swift separation when necessary, without the need for the employee to remain in service during the notice period. Even if the contract does not explicitly state payment in lieu, it is generally understood in employment law that an employer who wishes to terminate an employee's service immediately without requiring him to work out their notice period can do so by paying the employee what they would have earned during the notice period. This is an exercise of the employer's right to waive the notice period, provided the employee is compensated for it. It prevents a situation where an employee, having been given notice, might become disengaged or unproductive during the notice period, or where their continued presence might be detrimental to the business. The Labour Act prescribes minimum notice periods for the termination of employment and also provides for the option of payment in lieu of such notice. These statutory provisions serve as a baseline, and parties are generally free to agree to longer notice periods or more generously payment in lieu terms in their contract, but not less favorable ones. There is no evidence before this court that the defendant gave notice of termination. DW1 had earlier admitted to this during cross-examination. By Exhibit C1, the offer letter provides for 1 month notice, while Exhibit D2 provides for not less than 2 weeks notice. By Exhibit D3, by Exhibit D9, there's no evidence that payment was made in lieu of notice, either for 1 month or not less than 2 weeks. In the circumstances, this court is convinced that the defendant failed to make payment in lieu of notice in compliance with the offer letter of employment, and is hereby ordered to pay the claimant 115,000 naira as payment in lieu of notice. In summary, for the relief seeking 3 million naira damages against the defendant for unfair labor practice, wrongful termination, and loss of earning. This court, in view of the above decision, is convinced that the claimant is entitled to general damages which need not to be pleaded. In the circumstance, the claimant is entitled to general damages. However, having been paid 1 month's salary in lieu of notice, this court will decline to give the claimant double compensation, which the court frowns at. I so hold. Relief. This relief for 3 million naira is hereby declined. All monetary awards shall be paid within 30 days from the date of this judgment, failing with simple interest of 10% shall accrue. Failing with simple interest shall accrue at the rate of 10% until full and final liquidation. I make no order as to cause. Judgment is entered accordingly. This is the judgment of the court.
Thank you very much, my lord. We are very grateful for the welcome. This is our considered judgment. We are most grateful.
Your Lordship, we are likewise very appreciative of the well-considered judgments. We are indeed grateful for the industry of the court.